Aloha. Welcome to Abe Lee Seminars Sessions. Have you ever heard of the Real Estate Settlement Procedures Act, called RESPA, or TRID? Am I speaking Greek to you? Most people, when they hear these words, they space out and they don't know what the heck you're talking about. But this law is very important for people that are buying a house. And the documents that are required to give as full disclosures to the buyers of single-family homes for residential properties. So the Real Estate Settlement Procedures Act was passed in 1947. There's a new version of that law called TILA, RESPA, Integrated Disclosure Final Rule, which makes no sense to me, but that's a new updated version that was passed in 2015. The law requires that within 3 days after you apply for a loan to a lender, that the lender has to give you back a full disclosure of what the loan will entail and how much it's going to cost you. So you can make comparisons with other lenders that might be providing you the same type of loan, and you can compare the two. So if I make an application for a loan and I fill out the form, then the lender has to give me a proposal within 3 days, business days. They cannot charge you for that service. It's free. This loan estimate replaces what they used to call good faith estimate, and it used to be called GFE. People love to use acronyms in real estate and mortgages. So the loan estimate, now called an LE, replaces the good faith estimate called the GFE. It's the same thing. It's just that they might have a few little quirks and differences in the format, but it's the same basic information. The law applies to all lenders who are regulated by the federal government, which means pretty much everybody. And it's for 1 to 4 dwelling units. So if you're going to buy something for 5 units or more, then this law does not apply. But if it's 1 to 4 units, then the law applies. So most of the loans that people borrow, it's going to be falling under this category. So it includes itemization of origination and settlement charges and estimated cash to close. And now if you're borrowing money for the first time, you're buying a house, this is all Greek to you. You really don't know what's going on. So you need to have a good loan officer that will work with you and explain what's entailed in these estimates. Now, under the new law, there's a thing called a zero tolerance on the accuracy of things like appraisal fee, credit report fee, or items or services for which the applicant cannot shop around. And if these things are not 100% accurate, and they're going to now change the numbers, they have to give you 3 more days to review what they gave you from the original proposal that they gave you. So that extends closing dates maybe 3 days, which is not good for the borrower or the seller. There's also a thing called HUD-1 form, which is a settlement statement. And the lender or the escrow company has to give you a HUD-1 statement 3 days before closing so you can review all the charges and what we call debits and credits to the loan process. There's also a thing called Homebuyers Guide to Settlement Costs, and this is for new owner occupants, and it's a little booklet put out by the government to tell you about all the nuances of when you borrow money to buy a house. What should you know? Okay, things like the nature and purpose of each settlement cost, the HUD-1 form, and the escrow impound account. What is that? And its purpose? Examples of unfair practices. These are the things that are in that little booklet. Now, I've asked students of mine and agents, do your clients read this booklet? And most of them don't, unfortunately. They don't read the booklet and they don't really pay attention to these details. Now, they should, but they don't. Okay? The law also requires that kickbacks or payments of unearned fees may not be made by whoever's providing these services to the consumer. Okay? And there cannot be any kickbacks from these providers of services to to whoever they're servicing. If a lender says, I want you to use a specific attorney, a specific loan officer, a specific escrow company, or insurance company, or whoever, that is illegal. They cannot tell you who to use. And if there's a relationship between the provider of those services to the person that's making that recommendation, like it's your husband or your wife or your son or daughter or your relative, or you have an interest in that company that's providing those services, full disclosures must be made. And they also have to explain to you how much they're going to hold on the impound accounts for future taxes and maintenance fees, etc. And no fee can be charged for providing you with some of these information, as I mentioned to you before. Violators of the law are subject to criminal penalties, and triple damages may be awarded for violations. So the federal government is saying, hey, providers of these services, make sure you make the full disclosures and make sure that the consumer knows what they're being charged. And in some cases, as I mentioned, there cannot be any deviation from the quotes that were given. And if there are any, then the consumer has 3 more days to reconsider what they got. So hopefully RESPA is a little more understandable, although it probably isn't, but we have to disclose it. And the law says they must be disclosed to all consumers of buying 1 to 4 houses. Hope this helps. Aloha.